Hi, my name is Rain Feeney, and I'm going to be talking about hotel liability of guest property from common law to today. Providing hospitality to travelers is one of the oldest professions in the world. As such, the common laws that were established concerning hotel liability of guest property date back to as early as 14th century England. In 14th century England, people traveled considerably, but travel was hard and the means of transportation were often by foot, horse, or carriage, and took a much longer time than a travel would at this time period. And the dangers increased at night, with robbers and rough conditions plaguing the roads. Inns were not as common then as they are today and were often few and far between. Who were stopping at inns usually brought very little with them and only what was necessary, stopping only to find comfort and safety. Because of the vulnerable state of the traveler who was left without protection if a breach of trust should occur between the innkeeper and the guest, it became English common law that the innkeeper should have absolute liability for the lost items belonging to the traveler and the cost of, unless it was a case of negligence, fraud of the guest, or an act of God or the public enemy. This was called the doctrine of infra hospitem, meaning the innkeeper is an insurer of the guest's belongings. An example of this is in Hewlett versus Swift. An innkeeper was held liable for goods that a guest lost due to an accidental fire. As time progressed and economic and sociological changes took place, the dangers that inns were established to protect travelers from lessened. And so, with the reduction of loss and the threat of the dangers of the roads lessened, people started to bring items of greater value with them as they traveled. However, common law still held innkeepers as absolutely liable for the loss of items of great value, and in most cases the potential loss was out of proportion with the money the guest was paying. On July 13, 1863, the Innkeeper Liability Act of 1863 was passed, stating no innkeeper shall be liable to make good to any guest of such innkeeper any loss of or injury to goods or property brought to his inn, not being a horse or other live animal, or any gear appertaining thereto, or any carriage, to a greater amount than the sum of £30, except in the following cases, that is to say: 1. Where such goods or property shall have been stolen, lost, or injured through the wilful act, default, or neglect of such innkeeper or any servant in his employ. 2. Where such goods or property shall have been disposited expressly in safe custody with such innkeeper. In the 1931 case of Carpenter versus Haymart Hotel Limited, the plaintiff placed her diamond ring in a jewel case and placed that in her suitcase, which she latched but did not lock. She then went with her husband for dinner, and her husband locked the door of their room and took the key with him. After dinner, the plaintiff and her husband returned to the room, and upon leaving to go dancing, the plaintiff's husband again locked the door and then handed the key in to the hotel desk. The next morning, the ring was discovered to be missing and was not found. In compliance with Section 3 of the English Innkeepers' Liability Act, 1863, a copy of Section 1 of that Act had been exhibited by the defendants in the public hall or entrance of the hotel. Wholly apart from the requirements of that Act, the defendants had also posted in each of the bedrooms, including the plaintiff's, a special notice that the company will not be responsible for anything lost through visitors not locking their doors. All articles of value should be deposited at the office and a receipt obtained for the same. All instructions as to safe custody of luggage should be given to the hall porter. The action was for the loss of the ring, the claim being restricted to £30 under the Innkeepers' Liability Act of 1863. The Innkeeper Liability Act of 1863 was repealed and replaced with the amended Hotel Proprietor Act of 1956 by Queen Elizabeth. The third section of the act referring to liability states, where the proprietor of a hotel is liable as an innkeeper to make good the loss of or any damage to property brought to the hotel, his liability to any one guest shall not exceed £50 in respect of any one article or £100 in the agrate, except where the property was stolen, lost, or damaged through the default, neglect, or willful act of the proprietor or some servant of his, or at a time after the guest has arrived at the hotel, either the property in question was offered for deposit as aforesaid, and the proprietor or his servant refused to receive it. Provided that the proprietor shall not be entitled to the protection of this subsection unless at the time when the property in question was brought to the hotel, a copy of the notice set out in the schedule to this act, printed in plain type, was conspicuously displayed in place where it could be conveniently read by his guests at or near the reception office or desk, or where there is no reception office or desk, at or near the main entrance to the hotel. The modern legal framework when it comes to hotel liability hasn't changed much since then. Many jurisdictions have modified this rule so that the hotel's liability is limited even further. In order to have limited liability, the hotel must abide by certain regulations. Hotels are to provide safes for guests to store their valuables. Hotels may also post notices that say valuables above a certain amount must be put in the safe in order to be covered for their loss. Hotels can limit their liability by posting notices that say they are not liable for guest property or that guests waive liability if they don't use the safe. Hotels can limit their liability by taking reasonable steps to protect guest property. For example, hotels should ensure that safes are locked, meet local fire codes, and perform background checks on staff. Hotels can limit their liability by keeping their property safe and well maintained. This includes inspecting the grounds, making repairs, and demonstrating a commitment to safety. Is this a positive change or a negative one? I think that the changes in the law have a positive impact on liability in the hospitality industry, making it more fair for the innkeeper who are being held to the standards of laws from a different time when the circumstances were very different.